Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the Indian family law. Adoption under the Hindu law holds great importance when it comes to questions asked in competitive exams. Before getting into the provisions of the Act, let us understand a little about the practice of adoption itself. According to Section 2A of the Juvenile Justice, Care and Protection of Children Amendment Act 2006, adoption has been defined as the process through which the adopted child is permanently separated from his biological parent and becomes the legitimate child of his adoptive parents with all rights, privileges, and responsibilities that are attached to the relationship. It is the permanent transfer of all parental rights from one person to another. This process has a generational impact on the family. In India, adoption has been in practice since the ancient times. Epics and historical records have compiled data of saints and royals who had been adopted themselves and who engaged in the practice. Ramayana and Mahabharata are two epics which suggest references to adoption. The English law started recognizing adoption during the latter half of the 19th century. It was recognized as a legal concept for the first time in 1926 with the passing of the Adoption of Children Act in England and Wales. The purpose of this Adoption Act was to prevent the biological parents from claiming back their children. Modern adoption laws came into existence only after the First World War. The main reasons were the influenza epidemic and the aftermath of the war. Many kids were abandoned by their parents, others separated from their biological families. The confusion and chaos caused due to the war influenced many countries to enact new legislations or modify previously existing laws on adoption. The Hindu Adoption and Maintenance Act of 1956 is applicable to Hindus, Buddhists, Jains and Sikhs, as well as sects like the Veerashaiva, Lingayats and members of the Arya and Brahmo Samaj. As a matter of fact, the Hindu Adoption and Maintenance Act covers everyone residing in India who is not a Christian, Muslim, Parsi or Jew. It is the only personal law governing the process of adoption. It has been derived from various sources like the Manusmriti, Dharmashastras and epics. Adoption has been described in Manusmriti as taking someone else's son and raising him as one's own. This ancient definition included only for the adoption of a son and has since been broadened in the Hindu Adoption and Maintenance Act by allowing the adoption of a child and not just a son. It is considered to be a sacrament due to the belief that a son was essential in attaining moksha or salvation, and the belief that a son was indispensable for spiritual as well as the material welfare of the family. It treats the adopted child for all intents and purposes like a natural child. The English law of adoption is very similar to the Hindu law of adoption, inasmuch as that it lays down that the adopted child, for all intents and purposes, becomes like a natural child, and the child's ties with the natural family are severed. As per Section 9 of the Hindu Adoption and Maintenance Act, no one but the parents and the guardian of the child are capable of giving a child an adoption. The father of the child, with the consent of the mother, if she is alive at the time of adoption, is capable of giving a child an adoption. However, this consent is not necessary if the mother has renounced the world, ceased to be a Hindu, or is of unsound mind. Similarly, the mother of the child is capable of giving the child in adoption if the father is dead, or if he has renounced the world, ceased to be a Hindu, or is of unsound mind. The guardian of the child is capable of giving a child an adoption when the parents of the child are dead, have renounced the world, abandoned the child, are of unsound mind, or where the parentage of the child is not known. This process is possible only with the permission of the court, where the court must be satisfied that it is for the welfare of the child. In the case of Miss TEESTA CHATTORAJ versus Union of India, the couple went through a divorce and mutually decided that the child would be maintained by the mother. The child was given away in adoption by the mother without the consent of the father. When she applied for the passport of the child, she was informed that only the name of the biological father could be entered in the passport, and the validity of the adoption was challenged. The court held that the adoption was not valid since the father was alive and his consent had not been taken for the same. It also clarified that giving up maintenance rights did not amount to the father renouncing the world. Section 7 of the Act states that a Hindu male willing to adopt a child must fulfill a set of conditions. He should have attained the age of majority, be of sound mind, and must have a wife that is alive and consenting to the adoption. However, her consent is not necessary if she is incapable of giving the same due to insanity, or if she has renounced the world or converted to another religion. If he has more than one wife living at the time of adoption, the consent of all wives is necessary. Section 8 of the Act states that a Hindu female willing to adopt the child must fulfill a set of conditions. She should have attained the age of majority, be of sound mind, and if married, must have the consent of the husband, unless he has completely renounced the world, ceased to be a Hindu, or is of unsound mind. Under this Act, an adoption is said to be valid only if the conditions set out in Section 6 of the Act are abided by. These conditions are as follows. The adoptive parents have the capacity and rights to adopt. The person giving up the child for adoption has the capacity to do so. The person being adopted has the capacity to be taken in adoption, and the adoption is made in compliance with the Act. Section 11 of the Act sets out other conditions and rules for a valid adoption. Section 11 Clause 1 of the Act states that the parties seeking to adopt a son must not have a living son, grandson, or even a great-grandson at the time of adoption. Section 11 Clause 2 lays down similar rules for the adoption of a daughter and states that the parties wishing to adopt a daughter must not have a living daughter or a granddaughter from their son at the time of adoption. It is irrelevant whether the son or daughter is legitimate, illegitimate, or adopted. A Hindu male willing to adopt a girl child must have the capacity to adopt a child as prescribed under Section 7 of the Act, and according to Section 11 Clause 3 must be at least 21 years older than the girl child that is to be adopted. If a Hindu female wants to adopt a male child, she must first meet the requirements prescribed in Section 8 of the Act, and according to Section 11 Clause 4, must be at least 21 years older than the child she wishes to adopt. Section 11 Clause 5 states that the child cannot be adopted by multiple people at the same time. Clause 6 states that the child that one wants to adopt must have been given for adoption as per the guidelines of this Act by their biological parents or guardians, with the intention to transfer him or her from their biological family to the adoptive one. These additional conditions have been framed in mind keeping the welfare of the child. Section 12 of the Act states that when a child has been adopted, all ties with the natural family are severed and he/she will have the same rights and obligations of a natural born child. They shall be considered as the child of their adoptive parents for all purposes and intents. The adoptive parent shall have all parental obligations and rights, and the child shall have all the rights and obligations of a natural son or daughter. The Act also prescribes certain rules the child has to abide by. The rules of the Hindu Marriage Act 1955 regarding the Sapinda relationship shall be applicable to them towards their birth family. He or she must not have any incestuous relationship with anyone from their biological family and should not marry anyone from their biological family. If the child had any property before the adoption, it shall continue to be in their possession after. However, such property may bring some obligations over the child, and he or she shall be liable to all those obligations, including having to maintain their biological family if required. The adopted child shall not deprive any member of his birth family of any property that he held before the adoption. In the case of SRINIVAS KRISHNARAO KANJO versus NARAYAN DEVJI KANJO, the petition was filed by an adopted child for his share in the property of his joint family's undivided property. The respondents had refused the same on the grounds that an adopted child was only entitled to ancestral property and not self-acquired property. The court held that when a child is adopted, the effect of adoption creates a legal fiction, and that the adopted child would be considered as a natural heir and is eligible for a share in the properties of the adoptive father. But the same is not applied to cases where the property belongs to someone else and the effect of adoption does not allow the property to be divested from that person. Section 15 of the Act states that the adoptions are permanent in nature if they are in compliance with Section 6 of the Act and are considered to be valid. These adoptions, once made by the parents, cannot be cancelled by the adoptive parents, nor can the adopted child renounce the adoptive family to go back to his or her biological parents. I hope this video was helpful in providing a simple and clear understanding of adoption under the Hindu Adoption and Maintenance Act. For further queries, please drop your questions in the comment box below.